mentioned that in POCSO, it is very important that this is a special legislation which is enacted to protect children from sexual abuse, exploitation, and pornography. So, when I say that POCSO has been introduced because it is a child centric justice system, meaning that the procedure must protect the child from further trauma during investigation and trial. So the one thing which is very important to understand here is that the constitutional provision under Article 15 subsection 3 and United Nations Convention on Right of Child to ensure safety and dignity. So the constitution provision Article 15 subclause 3 and United Nations on with regards to the child abuse needs to be taken into consideration. The reason being is that the key feature, my dear students, of this particular act shifts from traditional advisorial justice to protective justice. So now when I say with regards to what is the importance of this particular act, how we are going to learn in this particular hour with regards to POCSO is the three important theory, the three important pillars in POCSO is investigation, trial, and victim protection. Now, when I say investigation, trial, and victim protection, one thing which comes to the mind is that how the investigation starts. The first thing is that is very important for us is to go and report a first information report. Now, when I say go and report a first information report, is FIR is always been taken into consideration under Section 173 of Bharatiya Nyaya Suraksha Sanhita, stating very categorically with regards to any complaint which we need to register as an FIR, it is only done in Section 173. So under investigation, first process is when we start with the investigation procedure. The first thing is FIR under Section 173 of BNSS. Once when I say that after FIR, the very important thing comes into the pictures about the medical examination, the statements of the witness, the testimony of the witnesses, all the statements of the person accused and the victim. Second thing which comes into the picture is trial. But after investigation and before trial, there is one more procedure, that is an investigating officer filing a charge sheet. Now, very importantly, in law, what the legislation has been passed is that once an FIR has been registered, from that particular time, 60 days has been given officially under POCSO Act to complete the investigation and file a charge sheet. And if the investigating officer fails to file a particular charge sheet in those 60 days, then additional time the judge is going to give is for more 30 days, students. So exactly within 90 days, if the POCSO Act is saying that if in 90 days an investigating officer of POCSO case fails to file a charge sheet, then the accused is have that particular right to ask from the judge for a default bail. Similarly in Bharatiya Nyaya Suraksha Sanhita also, if any particular investigating officer fails to file a charge sheet within 90 days, in that case the accused are having a right to approach the honorable court with regards to for a grant of default bail. So in POCSO, it's not 90 days, it is 60 days. But if the facts of the issue, the relevancy of the facts, the evidence which is required to be proved in the eyes of law with regards to the accused, in that particular case, the investigating officer can always ask for a special extra time of 30 days. And in that particular case, 90 days chance can be given if the honorable court deems fit in this particular case. So please make a note that after investigation and before trial, 60 days time period to file a charge sheet. If the charge sheet is not filed within 60 days, extra 30 days is given on the again the discretionary power of that particular judge. And then also, if within 90 days also, if the investigating officer fails to file that particular charge sheet in POCSO case, then the accused has a right to go and ask for a default bail. Next is what I speak about is victim protection. In under victim protection, again we need to understand very important aspect is that here we have shelter homes, we have observatory homes, similarly what we have started in our juvenile justice system also. But again, the photos, the background of that particular victim, any identity basically, or any public document regarding to the idea and notification of that particular victim should not be released in the media or any publicly documents. So first thing what we need to understand, the POCSO is a child centric system, child welfare centric system. Three pillars of POCSO: investigation, trial, and victim protection. Anyone having any doubt till this particular two slides can please raise a question and ask. Okay, next thing I'm going to start with is, why do we require students to study this particular law? Now, when I say that, even when we was having our Indian Penal Code and Criminal Procedure Code, in that particular aspect also there were certain cases which have been raised by the honorable courtrooms where a child was been sexually abused, where a rape of a small 5-year-old child has been occurred, and in that particular provision also the honorable court has been able to give the justice in that particular case. So before 2012, child sexual abuse cases were handled under IPC provisions. But why POCSO was taken into consideration? The reason being is to fulfill the gap by recognizing the vulnerability, the psychological harm, and the power to imbalance between the child centric system. So again, I'm repeating, POCSO is a child sense. The reason being why POCSO has been implemented is because we need to introduce a special courtrooms and a process how to deal with those cases wherein a child is in a question mark. Now, when I say that a child is in a question mark, the first thing what we need to understand here is what is the age of that particular child in this POCSO case. Now, the age of that particular child in this POCSO case should not be more than 18 years, my dear students. So, when I say that a child of 12 years, 5 years, 16 years, 17 years, yes, the term we will be giving them is as a child under 18 years, is a child under POCSO will be treated as a child. So, many a times in courtrooms, it has been argued as such that even a 19-year-old, the parents used to termed as is a child karke. So in that particular aspect, law under POCSO is very stringent. To be notably understanding fact is that a child whose age is not more than 18 years and below 18 years will be considered as a child under POCSO. Very, very important, because there is a landmark judgment which I'm going to discuss further of the year 2025 by the Honorable Supreme Court, only discussing with regards to the age factor in POCSO. So the reason being is, before studying any law, my dear students, it is very important to understand the philosophy of the act. And hence, when I started my lecture, I stated very clearly that unlike other criminal justice system, POCSO does not detriment towards only of giving the criminal justification to that particular offender, but also at that particular time we need to understand the trauma, the psychological factor, and the rehabilitation process of that particular child, who is also known as a victim in the POCSO cases. Next. Now, when I say with regards to POCSO, we all know that POCSO is a gender neutral. So it doesn't mean that only a girl child can be harassed. It does not mean that only a girl child can be sexually abused. Does not mean that only a girl child can be sexually harassed. So hence there are many landmark cases which I'm going to discuss further. You will see that it's not only girl, but even a boy can be harassed and can be termed as a victim under POCSO case. So, what POCSO recognizes, my dear students? POCSO recognizes multiple forms of sexual violence, mandates reporting, and it presumes culpability in certain situations. And that is the reason to make sure that there is a speedy trial. The special courts have been embarked by our judiciary system. Now, when I say that a special court, the reason behind why our legislation and judiciary system have embarked and emphasized on special courts with regards to this POCSO case is that, my dear students, that the entire trial of this POCSO case needs to be completed within one complete year from the date of me filing an FIR today. Why one complete year? Because again, I say that this is a POCSO case. It's a child-centric welfare act, and that is the reason the entire process from my filing of charge sheet, first me giving the statement with regards to a complaint, that complaint turning into first information report under section 173 of BNSS. With from FIR, I'm going forward for my charge sheet. From my charge sheet, my entire trial is starting. Entire process needs to be completed in one complete year, and that is the reason we have established a special court for the particular POCSO case. The law shifts focus from accused centric to child centric justice. Now, very, very important part of today's session, types of offenses, what we are going to study is the first one which we are going to study is penetrative sexual assault. Now, in penetrative sexual assault, section 3, it is very important to understand that it involves penetration of sexual organs or objects. It includes the penetration of any type of organ, any type of object in oral, in vagina, or any anal penetration. It is point to be noted here is students that even a minimal uh, penetration is sufficient to prove that this is a penetrative sexual assault. And the punishment for this particular section 3 is minimum 10 years, and it can be extended to lifetime imprisonment as well. This is one of the serious sexual offense under POCSO. So please make a note, penetrative sexual assault. Next is aggravated penetrative sexual assault. Section 5 of this particular act states that it occurs again a penetrative sexual assault, but when, my dear students, when it is committed by any police officer, when it is committed by any armed force member, when it is committed by any public servant, any teacher, any guardian, any family member, any person who is basically in a particular trust, or I can say that on a child who is below 12 years of age and causing grievous hurt. And by causing grievous hurt, I mean that even if that particular child becomes pregnant or leads to a death, it will be always be termed as an aggravated penetrative sexual assault. Minimum punishment for this particular crime is 20 years imprisonment, and in extreme cases, Honorable Supreme Court has extended to life also and death penalty as well. So this is very, very important. Penetrative sexual assault, aggravated penetrative sexual assault. Next is sexual assault. When I speak about sexual assault, here it is very to be noted that it's a non-penetrative sexual assault, my dear students. So when I say non-penetrative sexual assault, it is very much important to know that when I say that you are making that particular child feel in an unsuitable manner, any physical sexual contact, but wherein there is no penetration involved, in that particular case, in practical aspect, in courts, we always refer to this particular section 7 as sexual touching offense, for which the punishment is 3 to 5 years of imprisonment plus fine. Next is aggravated sexual assault, section 9. Same as sexual assault, but in aggravating factors, wherein again it has been committed by any police official, any army official, any teacher, any guardian, any family member. But here again, it is very important to know that if aggravated sexual assault is committed against a child who is of a disability, when I say a child is of a disability, even though when there is no penetrative action, the term will be considered as an aggravated sexual assault. Next is sexual harassment of a child. Section 11 speaks about that it includes showing pornographic films or making sexually remarks, asking for a sexual favors, making sexual gestures, stalking a child, threatening for a sexual purpose. Everything, my dear students, it will be coming under the term sexual harassment. And the punishment which the POCSO Act has been levied under sexual harassment is up to 3 years. It means it can be 1 year, 2 year, but the maximum year for sexual harassment is up to 3 years of imprisonment plus fine. The next is use of child for pornographic. It means that using a child in any pornographic material, storing, distributing, or creating any child sexual content, any online exploitation of that particular child. In that particular case, punishment is 5 years if the offender is a first time offender, and punishment is 7 years if I say that that particular offender is a habitual offender. So first time अगर offense किया है of using of a child for a pornographic, then that particular case it is 5 years. And when I say that he's a habitual offender, in that particular case POCSO is levying a 7 years complete imprisonment. Next is abatement of offense, that assisting or encouraging commission of an offense, not being a direct part, but aiding someone or assisting someone and helping someone to create such type of heinous crimes, then that also section 16 is not going to leave. Attempt to commit offense, attempting to commit a sexual offense even if not completed will be taken as a case, and it will be registered against that particular offender. Is this very clear types of offenses, everyone? Any doubt in this? Chalo. The next one, what I'm going to discuss is about reporting and FIR. So, as I previously, when I started the lecture, I stated that how the reporting needs to be done. The first thing is that if I say that the parents are willing to file a complaint, so the first thing that we have to go to the police station. Once I meet the police station, it is very important to know that there has to be a one woman police officer in present when I'm starting my case, when I'm presenting the facts of the case. So one woman police officer, very mandatory whenever there is a POCSO case to be heard and to be taken note of. So when I say a police officer is there, they have started taking a note of. The first thing is that particular child is not going to be in that particular police station at all. The reason being is again the trauma the child is going to suffer doesn't come under the POCSO Act, because again this is a child centric approach. So it is a mandatory reporting. Any person who has knowledge or suspicion of a POCSO offense must report it to the concerned police station. Failure to report also is also one of the uh, punishment in this particular act. So when I say I went to the police station to give my report, after reported, but always the witness is going to come, the testimony is going to report it, and then slowly and steadily my first information report is also going to be taken on place. First information report, again I'm repeating, section 173 of BNSS. After that, the after investigation and before trial, as I said earlier also, important is that the charge sheet needs to be filed. Default is given charge sheet only for 60 days, my dear students. Extension of period of more 30 days is given, but only again the discretionary power of the honorable court. So one thing which is very important here to understand, that in investigation also, when the medical procedure needs to be enacted, it needs to be enacted in a very child centric approach. That child should not feel as a trauma, that the interrogation of that particular child should not take place in the concerned police station as well. The questions which are going to be asked to the police station by the concerned police authority, it is very important and mandatory that the investigating officer who is going to lead this particular POCSO case should always be in a civil dress in front of that particular victim, so that the child does not feel that why police is questioning me. Always civil uniform, very important, civil dress. And the questions, the or the statements of the victim always needs to be registered at a place where the particular child feel safe. It can be school, it can be any garden, it can be any place, or at respective residential premises, or any type of area where that particular child feels very safe. So this is one again very important aspect of reporting. When I say protection from police trauma is also one of the very important aspect. The reason being, the act prohibits repeated summoning of the police stations. Now for an example, if tell you that I being an investigating officer, I am meeting a particular child to take the statement of whatever happened with him or her. In that particular case, where I met him today, I cannot directly go and contact tomorrow to with that particular child. For that I have to seek permission from the honorable court. The reason being is, again and again summoning and asking that particular child leads to mental trauma, leads it will definitely affect the mental health of that particular child. So it is very mandatory to note again in POCSO, unlike in a different criminal case, if I find that I want to call this particular person to give one more witness where I'm confused with regards to the data, I can call n number of times. Being an investigating officer, I can summon n number of people relating to my case. But here it is very important, even though I know that I'm questioning a victim, I want to take the statement. I know that the entire statement of the victim is going to be base of my further investigation. but again and again I cannot summon and ask that particular child. The reason being is honorable court is not going to give me the permission for the same. Even it is point to be noted here is that I cannot extend my time limit from what honorable court has given to me. As an investigating officer, court has given me only 3 hours for the investigating procedure with regards to that particular victim of a child. If I extend it more than 3 years, I'll be questionable and I have to give the representation in front of the courtroom that why my lordship I was delayed, and that delay needs to be justiciable in the eyes of law. That much important POCSO is, my dear students. Coming forward, when I say with regards to it, the role of child welfare committee comes steps into the picture as soon as a POCSO case is registered. Yes, we also call as CWC. What is the role of child welfare committee? The role of child welfare committee here is to ensure immediate care, arrange counsels, arrange counseling for that particular victim, coordinate shelter if needed. Because many a times, if I say that a family person, a family member is involved in the heinous crime, then we know that the child is not safe even in the family. So if such type of situation occurs, then the CWC will take a note that a shelter is also required where child feels safe. So next is the CWC will take care of the monitoring of that particular child safety. So this is again very important. Now, when I say that reporting is done, FIR is done, and the charge sheet is also been filed, the next step, my dear student, which is going to start is with the investigating procedures. Now, when I say investigating with regards to the trial, that whether this particular victim has actually suffered a loss, or and the offender is actually accused of this particular crime. When I say special courts are designed, because POCSO maintained a special courts for a speedy trial, for a speedy disposal. As I rightly earlier said that within 1 year of me giving the um, FIR needs to be registered. Within 1 year, once an FIR is registered, I need to clear my case. I need to dispose the case within 1 year of FIR being filed. So this coast must prioritize child testimony and avoid unnecessary adjournments. Many a times court also give an in-camera proceedings. Why in-camera proceedings? Because looking at the environment of a particular courtroom becomes very traumatized for that particular child to come and give the testimony in the witness box. To stop all this, to stop the trauma to be faced by that particular victim, in camera proceeding trial is always been allowed. But again, for the same, you need to be justified. The public prosecutor, the prosecution needs to be justified. Justiciable statement needs to be produced before the honorable court that why my lordship I want this particular case in camera proceedings, in camera trial. Again, this is very important aspect. Next is that child friendly courtrooms, judges must ensure that direct contact from the victim. It is again very important aspect ki that particular child should not again see that particular offender. So children may testify via video conference also, and the children can testify off camera trial also by sitting in the chamber of that particular judge. Also the proceedings can be held. Very important. There is a child line which is very important, wherein we have a special juvenile justice unit, SGPU, we say, and the child line number is 1098. Please make a note of a child line helpline number is 1098. Time bound trial, as I say, that without any causing any psychological harm to that particular victim, it is very important to complete the entire trial within 1 year of that particular FIR being taken into consideration. Any doubt till here, students can raise questions. Okay, I'll move forward. As I have stated, when the investigation starts, investigation should be preferably be start when there is a woman police officer. As I said, it needs to be child friendly manner. Statement can be taken at home or any place where that particular child feels safe. Child cannot detained overnight. There is a particular hours wherein you can ask the questions from that particular child. When I said that if the time is given only for 2 hours, and if I extend it for 3 hours, I have to give the justiciable statement to my lordship why 1 hour was being delayed. Next is that child's identity should be kept confidential. Wherein there was a one landmark judgment of the Supreme Court where I like to discuss here is that the question was raised in the media that using the blur photographs of the victim, will that also will cover under the investigating trial that this is an offense? So answer is yes, my dear students. Using blur photograph, it means that indirectly you are giving the identity of the victim. Even that is something which is punishable offense in POCSO. Protection from harassment or intimidation. Report submitted promptly to special court so that enables special court to give the final verdict of the case. Child informed children should be informed about the legal aid and the compensation which they are going to get from the court. Next is very very important, medical examination of a child. Again, when I say when we are going to for the reporting of an offense, it is very important that immediate medical care has been given. When I say immediate medical care, it doesn't mean that I will say that my child, I will go to my family doctor, I'll get a medical certificate and that I will tender to the investigating officer. Answer is when I say a medical test is required, it means that one police officer with one particular other police officials will go to a respective government hospital, will be analyzed by the same. Again, a female doctor needs to be there, present to be there to conduct the examination of a child over here. And the report which that particular doctor is going to submit, the same needs to be given it to the investigating officer. In turn, investigating officer is going to lead the particular case with that medical examination report. Once, and it is very important that before we conducting a medical examination of a child, consent needs to be obtained of parents or any guardian under whom the shelter that particular child was. Consent of a child is also equally important. If the child says that today that child is not in that particular situation to go under a medical examination, in that particular case the medical doctor cannot start the examination. Once the medical exam is done, then the further point comes of collecting the evidence. Now, when I say collecting evidence, it is very important to collect evidence. Again, investigating officer will start his investigating procedure to get that particular evidences into picture. If I say that I require testimonies from n number of witnesses, I can call n number of witnesses. But to call again that particular child, again I need to take permission from the honorable court. As I said, confidentiality needs to be maintained. No public document of this particular case should be made publicly available. No photo, no video, nothing should be leaked. If that is a punishable offense under POCSO. Report to police. Psychological call support is also there. When I said psychological call support, it is always children welfare committee is going to take a lead of this particular fact. Before starting a trial, like I we know that within 1 year we need to meet, evidence should be recorded within 30 days, atmosphere should be very friendly atmosphere, identity of a child must be kept confidential, frequent adjournments which is going to happen in many of the criminal case cannot be done here because the time limit is only 1 year. And the courts ensure here is of dignity and safety of a child. Compensation must be awarded. Legal aid and counseling service are being provided free of cost by the special public prosecutor conducts a case. Now, when I say before starting with the victim protection, one landmark judgment which I like to discuss with you all is Romeo Juliet case. Anybody aware about what is Romeo Juliet clause, and from which case this clause has been interpreted by the Honorable Supreme Court? Anybody idea? A little bit idea? We can have this session as a participative session, my dear students. Anybody having any idea with regards to Romeo Juliet clause? If I'll ask what do you mean by Romeo Juliet, everybody will answer me. Okay. In the year 2025, government of state of Uttar Pradesh have filed an appeal in the Supreme Court of India with regards to a question of the age. When I started, I said that a child under POCSO is a child who has not completed 18 years of age. So here, the state of Uttar Pradesh went in appeal in the Honorable Supreme Court in the year 2025, wherein the state of Uttar Pradesh has acquitted that particular accused in just because there was a not proper documentation with regards to his age. So when the state of Uttar Pradesh went in Supreme Court for an appeal, Supreme Court very categorically stated that we will not be dealing with the bail procedure, bail plea of this particular accused. But one thing what which needs to be added and which needs to be considered in POCSO, that is we need to add a Romeo Juliet clause. Now, this particular Romeo Juliet clause was been this particular divisional bench, the divisional bench of Honorable Supreme Court, who have taken out this Romeo Juliet clause is Justice Sanjay Karol and N. Kotiswar Singh. It's a divisional bench, and they have decided and they have requested the Union Legislature to kindly add this particular clause in POCSO. What is Romeo Juliet clause now? Romeo Juliet clause is a statutory exemption for consensual and non-exploitative relationship. इसका मतलब, my dear students, those victims who are when both are minor. Yeah, very good, Ritika. When I say that they are very close to 18 years of age, it means that when I say that there are 16 years of age, wherein they are 17 years of age, and they know what they are doing, and they know that this is the consensual relationship between both of them. They know that they have given their consent for this particular aspect, and then even though then the parents are going and filing a case of POCSO against that particular, I will say, a partner, not a criminal, not an accused in this particular case, then this Romeo Juliet clause is going to save, and the case will never ever be taken as a POCSO case. The reason being is adolescents who are close to 18 years of age to be prosecuted like a criminal prosecutions. Now, the point comes that if I say that I am a 16-year-old child, I am a 17-year-old child, we know both of them that in this particular activity, we both are giving our consent. And in future, the one of the parents take a lead of a case of a POCSO and goes and file a false FIR. So, how to assess this? The three pointers which the divisional bench of the Supreme Court has given is, please make a note. The first pointer is the nature of the relationship, my dear students. That when I say that the consent was given, when I say that they were in a consensual relationship, when I say that they are not supposed to be prosecuted unlike like in a criminal trial, it means that it is very much important here, firstly, to establish is that what is the nature of this particular relationship. Second one is the intent of both the parties. When I say there was